where the patient rush to the police station and my doctor get a call from the police, my doctor get a call from authorities, my doctor get a summon from authorities, my doctor get a summon from the police, and this terrorized my doctor. And the worst scenario which my doctor faces is a death on table. Very rare, but 4 or 5 local anesthesia that in dental practice I have handled. I know it is rare, but it is there, and which is beyond your control. In spite of giving a local dose, in spite of giving a test dose, I found that post local anesthesia, patient got an anaphylactic reaction and died. We all need to be very careful. But one thing, remember, my friend, never ever get terrified in your practice, even if medical accident is in the form of death in your clinic. Because law says that you are a doctor, you are not a god. Law says very clearly, you can do best for the people, but you cannot give life to every single person. Law also accepts that possible of misadventure is very common in a medical practice. For every misadventure, doctor must not be held responsible. Hence, even if there is a table death, which is very rare, never ever get terrified, because you have been protected by the law for arrest. You cannot be arrested on the spot. That is the law of the land when I talk about doctor. I say so because 304A, the normal section which normally used to apply to my doctor in a death case, which says that causing a death without intention with a negligent act, like you are given a local anesthesia, xylocaine, and patient got anaphylactic shock and died. Definitely it comes under negligence, but not otherwise. If it is proven, then only 304A applies, which is a nominal section, my friend, which attracts maximum 2 years of punishment, bailable offense. Nothing happened to my doctor. Finally, it is on base of evidence. The prosecution need to prove that it is gross. And Honorable Supreme Court has interpreted the law of 304A in respect to occupational negligence and a professional negligence. Occupational is, so the same section applies to driver who caused the accident and death. Same section applies to the doctor who caused the death. But here, the court has given added advantage to professional because they wanted to protect the professional. And court has said, with a trembling hand, doctor cannot do a surgery or give a treatment to their patient. Hence, they need to be protected in this country. And for the purpose of a protection, law very categorically said that doctors should not be arrested. And it was an observation done in this judgment that human body is a complex machine. Medical science is a complex science. Hence, for every medical accident, even in the form of death, doctor not be criminally liable, must not be made a criminal liable unless due care has not been given. So what is the expectation of the court from our side? That have we given a care or not? So if anaphylactic shock occurred, you have seen the complication. Have you acted to give the life? Like you have done resuscitation, or you have called some of the consultant friend, or you have shifted a patient to the hospital. Have you tried and done all these things? If you have done all these things, law says that you are not responsible. And second, the same judgment says to fasten a criminal liability against doctor, it need to be gross. Gross which can be seen from the eye. And in medical practice, it comes under simple negligence, not under the gross negligence. Gross means where instead of right, you amputate a left or mop left inside. So that need be seen to be, it can be seen from the naked eye. So not to worry, my friend. But yes, if I talk about 304A, it is interpreted, but 304 plain nowadays has been widely put on a doctor. Now, what this 304 says, try to understand little difference between 304A and 304 plain of IPC. Now, 304 of IPC says, causing a death without intention, with a knowledge that particular thing can lead to death. The moment knowledge component comes, the bailable offense becomes non-bailable and punishment goes to 10 years. And here is a warning to all my doctors. Let me cite an example to you. There was a doctor who has removed the tooth of a patient because patient was in a pain. Patient has given the history of a diabetes. Relative also has given a diabetic history. But since it was a simple procedure, doctor has removed the tooth without doing even simple blood sugar. Normally, we all say that glucometer need to be with every doctor, where they can immediately do AGT. But that was also not done. Next day, patient got infection, followed by septicemia because her blood sugar was 500 plus and died. Now, in such a scenario, the knowledge component comes in a picture. They're having a knowledge that patient is diabetes, having a knowledge that diabetes can lead to infection, and that I have carelessly done the procedure on a patient, leading to death of the patient. So knowledge component. I've got a case where patient was on blood thinner. Basic CBC was not done to ascertain, basic INR was not done to ascertain the level, and blood thinner was not stopped, and procedure of implant was done on a patient which leaded to profuse bleeding and continuous bleeding. And then patient got admitted to hospital, later died. Maybe because of embolism, because of whatever the reason, but then my doctor was troubled. So having a knowledge is going to be a big component in this domain. So my friend, my humble request to all my doctors, because you are involved 90% time in a procedure. You don't do conservative treatment. For conservative treatment, patient goes to medical store, not to you. When patient comes to you, it is found that 90% doctor does some procedure on a patient. Maybe tooth extraction, maybe RCT, maybe implant, maybe bridge, whatever. But that definitely comes with the procedure. The moment you do a procedure, you are bound with every law, including your maintaining of a consent, including maintaining of other things and all. And when you are known as dental surgeon, BDS means Bachelor in Dental Surgery. You just imagine where your status is and how big status you find and big. So here you need to be very careful, my friend. So you should not be careless. When doing a procedure, do basic investigation. No harm. Patient can wait for 1 day, but do a proper investigation. Otherwise, 304 section is non-available section. 10 years punishment.